All right, well, good afternoon. I got to listen to the panel before, and so I think that we're going to be building on that. I'm only going to briefly, since we're already a little bit behind, I'm going to briefly introduce my panel, my very esteemed panel of professors who know much more about this than I do. And I think I am the only judicial panelist other than Judge McConnell, who is a recovering judge, I believe, but I'm still well into it as a judge on the U.S. Court of Appeals for the Ninth Circuit. So we have 4 professors, and they come from the East and the West Coast. I think I have 2 East Coasters and 2 West Coasters. Eric Bieber, who is pronounced just like Justin Bieber, and so we'll be believers in you as that goes, is at UC Berkeley. It's the formerly known as Bolt, or is that formerly known as Prince, I guess, the professor of law at Berkeley Law, and his teaching primarily research interests are in environmental and natural resources. And all of my 4 panelists were law clerks, which I was not, and I have, I think, at least 2 Supreme Court law clerks as well. So they're extremely qualified, and I think you can see Eric has written, he clerked for 2 different circuit judges and has written a number of law review articles and articles that have been recognized for their excellence in the field of environmental law, one of the top 10 law review articles in the field of environmental law in 2011, and also as in terms of as a junior legal scholar, he was recognized to have completed one of the top pieces of scholarship. Then then Zachary Price. Zachary tells me he's older than he looks, but very knowledgeable, and he hails from Hastings, where he is presently teaching, and he clerked for Justice Anthony Kennedy, who was the Ninth Circuit judge in Sacramento, and that's where I sit at this point. So I stepped into those very large shoes, taking over that position. And he has many publications that you can see that he's going to be talking that include enforcement discretion and executive duty. Next, we have Jonathan Turley, and he hails from George Washington University, but he's going to, I asked him, how much does he teach? Because he has all sorts of cases that he's trying, and he seems to be more active than most practicing attorneys that I know right now. And he was the youngest chaired professor in the school's history, and he's going to be talking a lot. I think, interestingly, he's representing the House right now involving some challenges to the Affordable Care Act, does national security cases as well. And so he will be giving us very much of some practical considerations and his concerns about the separation of powers. Then to my left, immediate left, is Mark Tushnet, and he is a William Nelson Cromwell Professor of Law at Harvard. And as you can see, he clerked for George Edwards and Justice Thurgood Marshall, and has co-authored. I don't know how he has time to do anything when I look at all the books that he's written, but 4 of the case books, including the most widely used case book on constitutional law. So I'm very excited. I don't want to spend any more time going into the specifics, but we have a very qualified panel here. And as I told you, I'm a judge, and I did moderate a panel last year, and what I found is I build my confidence during the year. And then I come back and then I feel like, what am I doing here? And especially since we're dealing with the 4th branch of government, and as it is, I'm already in the 1, 2, 3rd branch of government. So that puts me at 3rd, but now the 4th seems to supplant the 1st, 2nd, and 3rd. So I'm really wondering, even though I'm working really hard, exactly whether anything that I'm doing is really very important. So in administrative terms, that means I'm stuck mediating many times between agencies, Congress, the courts, and the public about the extent of everyone's authority and whether the authority has been properly exercised. And you heard in the last panel talks about standing and who decides standing and all of those issues, and we will be touching on some of those issues. administrative law cases often boil down to the question of who decides. Federal agencies come to court and tell judges to sit down and keep quiet, to defer to their decisions of expert agency officials who are at least more politically accountable than we are, because we're appointed for life and in good behavior. Then other litigants come to court and tell us judges that we may not abdicate our duty to ensure that the agencies follow the law as Congress intended. So judges can carry their own agendas to court as well, and we must be reminded of the confines of Article 3, and we work very hard on that. Now, we'll decide here if the other branches are working as hard. Now, today I'll take a similar role moderating this panel, waivers and licenses and other case-by-case decisions. Where is the rule of law? So hopefully we'll find that at the end of this panel, but if not, you can work on it till next year. We'll hear from the academics and in the practitioners who welcome broad agency discretion in implementing or not implementing the law. And we'll also hear from the academics who favor a more limiting agency discretion so as to protect the role of the legislative branch. Now, I'm going to try to keep this adversarial by asking a few questions after we hear from each of my esteemed panel members. And I'm going to be particularly interested in what they say my role is because, as I said, last year it was on originalism, and I was convinced after that that there is no judge that can write an originalist opinion. And this year I'll see what I'm going to take forward and do before your next conference. But I will be particularly interested in what that role is, and hopefully that will be a little bit of a different exploration than what you've done in some of the other panels. And at last, we will leave time for our audience questions. And as I noticed in the last panel, there is no absence of opinions in this area, and that you all seem to be pretty expressive, and we certainly welcome that. And tell us what you think, and then if you have a question for us, we would really like to hear that. So we have an order that we're going to proceed today, and I think first out of the box this morning is going to be Zachary Price.
Well, first of all, I want to add to the chorus of praise to Michael and Judd for organizing such a wonderful conference. I'm really honored to be participating, and I've enjoyed it a great deal. So I plan to talk about executive enforcement discretion, the executive authority not to enforce federal laws. It's an issue that's obviously already come up several times, and there'll be some overlap in what I say with what others have addressed. But I think it's the core of these recent controversies over immigration, the ACA delays that Professor Turley is litigating. But I also think it's a recurrent separation of powers problem, something that's likely to remain important and deserves careful thought. So what I want to try and do is sketch a general separation of powers framework for thinking about the issue, what enforcement discretion is and what it's not. And then I want to offer, in keeping with the judge's instructions, some thoughts about the appropriate judicial role. And I want to suggest, perhaps somewhat counterintuitively, that although I think there's a significant potential for executive abuse in this area, there are also important practical limits on the judicial role. And it's important to think carefully about what courts can and can't do effectively in this area. In essence, my view is that law enforcement is, in important respects, a sort of political question. What I mean by that is it's an area where the executive branch has legal obligations, but for institutional reasons, those obligations are subject to incomplete judicial enforcement. So let me start with the scope of executive enforcement discretion from an executive branch point of view. What authority does the president have not to enforce federal laws? And in particular, the core question is, can presidents direct non-enforcement based simply on policy disagreement with the statute? There are a lot of confused judicial decisions addressing this issue from various different angles: standing, APA reviewability, selective prosecution. A common theme that runs through a lot of them is that there's some sort of preclusive executive non-enforcement power, so that even if Congress mandated enforcement of a particular law, the executive branch should be free to disregard that. I think that's wrong. Although broad prosecutorial discretion is obviously pervasive in many areas today, for reasons I'll come back to, I think the constitutional architecture itself actually implies a default rule of fairly limited enforcement discretion. To begin with, the Take Care Clause, other features of the constitutional architecture, such as the president's limited role in lawmaking, the basic idea of having an executive branch that executes the law. All these things, I think, impose a basic obligation on the executive branch to carry out statutory policies. I think making case-specific exceptions to enforcement is a natural incident of the executive function of applying general laws in particular cases, but making broader exceptions in principle conflicts with the basic executive obligation to execute congressional policies. And I think in particular, the constitutional architecture rules out presuming an executive cancellation power, what historically was known as a suspending power, that is an authority to relieve regulated parties of legal obligations by prospectively suspending a law's enforcement. That sort of authority was actually a historic executive prerogative, but it was repudiated even in the English context, and there's every reason to think that prohibition carries over to our constitutional framework, and indeed one core meaning of the Take Care Clause is to rule it out. So as a default matter, I think the constitutional structure implies limited executive non-enforcement power. Now, of course, normally that's not how things actually work today. As a practical matter, the executive branch does have huge discretion over how, even whether to some degree, many laws get enforced. Kind of the paradigm case here is criminal law, where the law obviously prohibits far more conduct than could ever realistically be detected and punished, but it's also true in many areas of civil regulation. I think the sort of discretion that operates in those areas should be understood as a function of legislative choices, of the choice to enact laws that as a practical matter can't be fully enforced because of practical limitations and resource constraints on enforcement. So again, to take the paradigm case, federal criminal law encompasses a vast range of conduct. It's inconceivable that the government could ever detect and punish all of it. So there's an expectation of discretion built into the system, and indeed Congress legislates against that background. Importantly, moreover, that process can be self-reinforcing. Congress can pass new laws reflecting highly punitive and aspirational policies because it knows they'll be enforced in a discretionary manner, but then in doing so, it ends up just expanding the discretion that executive officials have in the first place. But my basic point is that in many areas of regulation, there's this tremendous discretion, but it's a practical inevitability. It's not, in my view, a constitutional inevitability. And in addition, the anti-suspension principle, I think, also applies in these areas too. So if a central meaning of the Take Care Clause is to prevent prospective cancellation of legal obligations, then that's an important norm in this context too. So ultimately, enforcement discretion is an authority to prioritize. It's an authority to pursue one case rather than another because the government lacks the time and money to pursue both. It's not an authority to change underlying legal obligations. So that's my basic view of the scope of executive enforcement discretion. Now, I think the basic story across recent administrations is one of presidents chafing against these limits and trying to convert enforcement discretion into a more robust policy tool. The controversial current examples, the Affordable Care Act delays, the deferred action immigration policies, those fit this story, although there are other examples from recent administrations too. I also want to bring in another example that Professor Grieve touched on that I view as reflecting the same pattern, although I'd be interested in others' reaction to that. What I have in mind is the emergence of deferred prosecution agreements in the white-collar corporate crime context as an important regulatory tool. These are agreements where the government brings criminal charges against a defendant, but then agrees to postpone prosecution indefinitely if the defendant enters a court-approved agreement with certain conditions. This turned out to be a very powerful tool for inducing internal changes in large organizations, getting them to accept things like intrusive monitoring, even internal organizational changes. In one case, it got the defendant to endow a law school professorship, which, in general I support, but not in this way. But what I think connects this example with the others, the more hot-button current issues, is that they involve using enforcement discretion as a way to accomplish basically regulatory goals without an affirmative legislative delegation of authority. So we end up with a sort of jerry-rigged system of corporate fraud prevention based on leveraging the punitive force of federal criminal law into inducing other sorts of changes in behavior. So one question is, why is all this happening? This goes back to the theme the earlier panel about partisan division and legislative gridlock. I think that's an important part of the story in these areas. Why does that matter? I think gridlock matters because if obtaining legislative reforms is difficult due to gridlock, then it's probably inevitable that the executive branch is going to take broad views of its authority to act on its own. The executive branch is the branch that never sleeps. It has to address issues, problems as they arise. And what's more, at least in our current era, the presidency is the focus of national political attention. So there's an intense political demand on presidents to take action. Another feature of the environment, though, I think is important, is that we're now in an age that, as some other scholars have put it, is sort of thick with law. There's a lot of law built up prohibiting a lot of behavior, at least nominally, and much of it is designed to be harsh so that the government has leverage to achieve policy objectives economically with limited enforcement. I think that matters for a couple of reasons. One is just the general prevalence of discretion is part of what makes executive non-enforcement seem unremarkable or enables these sort of nothing to see here folks type arguments about it. But secondly, it's what underlies the importance of the issue. The fundamentally negative executive authority to abstain from enforcing particular laws or pursuing particular cases becomes important in this context as a separation of powers issue. Because if you have a lot of law and you have political contestation about the merits of policies reflected in existing laws, then that's why the executive power to cancel enforcement of those laws becomes important. Choices about how not to enforce laws can become just as significant as a policy matter as the sort of affirmative regulatory choices that are more conventionally the focus of administrative law. In other words, you get a parallel concern here as in more affirmative regulatory contexts that the executive branch is going to try and act in ways that fit its understanding of what the law should be rather than what it is. So that brings us to the question of judicial review, which of course has emerged and ordinarily is the main tool of applying statutory policies and enforcing them against the executive branch. And so the question becomes, if there's a risk of abuse in this area because of these structural forces, can we look to courts to remedy it? The trouble I think that emerges with that solution that I want to highlight is that you can quickly run into problems of judicial competence and judicial manageability in dealing with enforcement problems. To begin with, I think there's a strong argument that courts actually can't compel particular enforcement actions. I can elaborate on that if folks are interested, but I think the broader point I want to make is a sort of different problem presented by these general enforcement policies, potentially like immigration programs or the ACA delays or the Justice Department's marijuana enforcement policy. I think the trouble courts run into with this sort of policy is that they don't have a good legal yardstick for assessing whether the executive branch is faithfully implementing the statute. When you're in a situation where resource constraints are central to how the law operates, the executive branch has to pursue some things and not others, and it's very difficult for the court to draw something from the statute itself that explains why one set of priorities is better than another. Just to take an example picked largely at random, I mean, consider the Controlled Substances Act. The statute's prohibitory policy with respect to narcotics is basically aspirational. At the least, the government couldn't possibly detect and punish all violations with the resources it has. So huge exercises of discretion are going to be inevitable. But by the same token, there's a huge range of enforcement policies that potentially reflect a reasonable judgment about how to effectuate the statute's goals. You could focus on big violations, you could focus on small violations, you could focus on cocaine or marijuana, you could adopt a punitive approach or rehabilitative approach. In reality, some of those policies might be more or less faithful to the statute, more or less consistent with what the executive branch could best do to accomplish statutory objectives. But courts, I would suggest, have no real way of assessing objectively in a way that's based on the statute rather than some sense of their own sense of appropriate policy, whether the executive branch is living up to that standard. So courts don't have a good legal yardstick when you're talking about that sort of policy based on resource allocation and priority setting. So that's an important point, but in a way, the payoff of this is if that's right, if that's the right explanation for why courts shouldn't or are reluctant to involve themselves in these questions, then it throws into relief some situations where these problems of unmanageability aren't present and review is possible without any separation of powers difficulty. And I think the key example here is policies that go beyond normal exercise of enforcement discretion and amount to something more like a general suspension or waiver. The Affordable Care Act delays are perhaps the cleanest example. These are policies that just suspend for a specified period any enforcement of key provisions of the statute. The policies are designed to change legal obligations, to free regulated parties from responsibility to abide by statutory requirements. So this is a type of policy where a court can simply vacate it and in principle restore the deterrent effect of the statute and enforce the supremacy of the statute over the agency, even if the agency at the end of the day isn't going to actually bring any enforcement cases. It's nonetheless a significant enforcement of the primacy of the statutory policy to simply wipe away that sort of executive action. So in that way, I think courts can at least police the core principle that enforcement discretion is a matter of setting priorities and not a matter of changing regulatory policies reflected in statutes. Another context here where I think courts can play a role is when Congress has invited or required them to do so. And here is where I think the example of deferred prosecution agreements are relevant. By statute, these agreements require court approval, but courts almost never exercise any oversight over them. With just one very recent exception, they basically just rubber stamped the agreements despite some pretty obvious abuses, as I've mentioned. I suspect, there's actually only two opinions you've written about this, but it seems like the judicial reluctance is rooted in the sense that enforcement decisions are an executive prerogative. But I think here the statutory requirement of judicial approval should be understood to invite a more active judicial role that courts could usefully perform. So those are two important cases, at least, where you don't run into these unmanageability problems and review is possible without separation of powers difficulty. But I also flag a more general benefit, I think, to framing the issue in this way, as a matter of judicial manageability rather than executive prerogative. I think the benefit is that in situations where courts can't effectively provide a remedy, they can at least make clear that that's why they're not exercising judicial review, and that judicial review in this context does not necessarily exhaust executive obligations. And if nothing else, doing that might help to bring to bear congressional and political pressure on the executive branch to make responsible judgments. That's all I have.
Thank you, Zach. You're perfectly timed. For your other panelists to follow. Eric is going to next talk about permits and guiding agency discretion and enforcement of the law and contrasting the use of permits with prosecutorial discretion. Eric?
Thanks for moderating, Judge Callahan. Thanks very much for inviting me to participate in hosting. It's been a lot of fun. So I want to talk some about the roles that agency permitting practices play in shaping the discretion of agencies and in controlling the possible abuse of prosecutorial discretion or executive branch overreach. And I think this analysis can provide some important and distinctive insights on the current debates on these questions. So as Zach noted, I think it's inevitable that at times the legal system will be covering a wide range of private behavior within its scope, whether it's historic criminal prohibitions in adultery or other sexual activity, or current immigration law that covers millions of people within the United States. And there are, in fact, a lot of good reasons we might have laws with broad scope like this. For instance, an over-inclusive law might facilitate prosecution of behavior that is socially undesirable, or for which violations are extremely difficult to prove. On the other hand, technological change may cause an activity that was infrequent and prohibited to become much more frequent and much more important. And if the law doesn't change to keep up, then we have an over-inclusiveness problem. So in the early 20th century, Congress prohibited all killing of migratory birds in the United States. So keep that next time you try to kill a sparrow. And there's much more of a problem with that when we're putting up tens of thousands of wind power turbines that occasionally kill birds. There are many problems with relying on prosecutorial discretion to address the problem of over-inclusive laws. First, it can put tremendous power within executive branch officials who may, in the case of some prosecutors, or may not, in the case of police, be elected. Power can lead to abuse, such as corruption, either of a purely pecuniary variety, such as people taking bribes to overlook inevitable and frequent violations, or of a political variety, such as only prosecuting the inevitable and frequent legal violations of political opponents. And an excellent example of that latter case is Putin's Russia right now. Even if executive branch officials act with the best of motives, giving such broad discretion can lead to problematic differences in enforcement as the result of implicit bias. So, for instance, everyone violates the traffic laws at some point in time, but it is a violation of a traffic law that can then justify a police officer stopping a car and searching the vehicle. So it's perhaps no surprise that African Americans are differentially stopped more often and have their vehicles searched more often, as implicit bias shapes prosecutorial discretion by law enforcement. Another problem with sweeping prosecutorial discretion is that it is fundamentally disruptive to major economic investment in a regulated activity. If what you are doing is technically illegal, that will surely affect your ability and willingness to raise funds and invest in development projects. And again, this is not a hypothetical problem. The wind power industry has faced challenges in raising funds and building projects, in part because of the risk of liability for bird kills under the Migratory Bird Treaty Act. There is another alternative to using prosecutorial discretion to authorize an activity that would normally be prohibited. And in fact, it is an alternative that is so widespread and so fundamental to our regulatory state that it is kind of surprising it hasn't received more attention from administrative law scholars, and that's the permit. At its most basic level, a permit is an authorization by a regulatory agency to perform an activity that would otherwise be prohibited by law. But compared to prosecutorial discretion, it has a lot of advantages. It provides a legal safe harbor, one that provides protection against an enforcement action in court, whereas a promise by a prosecutor not to prosecute can be revoked by a successor or even at the same prosecutor at any time. It provides clear standards about when the permit can be obtained, and that permits usually have particular requirements to be satisfied before they can be granted. Prosecutors, unless they choose to provide guidance, something we've been talking about quite a bit in this conference, about how they will choose to exercise their discretion, need not do anything. Failure to grant a permit is usually reviewable by a court. As Zach noted, a prosecutor's exercise of their discretion is usually unreviewable by courts. And there are usually protections under the APA and other statutes before a permit can be revoked. A prosecutor can change their mind without any process at all. But of course, as soon as I mention permits, probably an entirely different set of fears and concerns enters into your mind. Mind-numbingly long permit applications, weeks or months or years to wait for an agency decision or permit, negotiations back and forth between the applicant and the permitting agency about whether the permit can and should be issued and on what terms, the need for lawyers and technical personnel to understand when permits are needed, how to complete them accurately and effectively, back-channel negotiations of the use of political pressures to get permits issued. Indeed, in the nightmare Kafkaesque world of permits, it starts looking a lot like all the negative features of prosecutorial discretion. Whether a permit is granted depends on the whim of an agency official. Permits are only granted within their discretion, which may be withheld or granted for a range of reasons. Delay in issuing permits may be far more important than whether judicial review for a final agency action is ever available. So we seem to be caught between two unappealing options, either the whimsy of prosecutorial discretion or the nightmare of the red tape of permits. But in fact, there is a third option, and it is an option that is in many ways more appealing than either. And it is also widely used by regulatory agencies, and yet surprisingly, again, has received very little attention from administrative law scholars, even though I think it can help resolve many of the tensions over agency discretion at issue in this conference. This third option is what my co-author and I have called a general permit, and it is indeed a permit, but it differs in substantial ways from the classic archetypal permit that I have discussed above, what we call the specific permit. Most importantly, general permits allow for permits that may depend much less on the discretion of the permitting agency, and require much less time and information to apply for by the regulated parties, and may have relatively simple standards by which they are granted or denied. All of these features, as I will discuss, can significantly reduce the risk of arbitrary discretion that can be posed in a regulatory program. So to give a sense of the distinctions we're drawing here, before I discuss the concept in more detail, I'll use some examples from a regulatory program that heavily relies on both specific permits and general permits. And that's the Section 404 permitting program regulating the development of wetlands under the Federal Clean Water Act. So those who are not environmental law fans, Section 404 of the Clean Water Act prohibits the dumping of dredge or fill material into the waters of the United States. And waters of the United States has in turn been interpreted to mean at least some wetlands, so not just lakes or rivers or streams. And that, of course, means that a whole lot of land use development all over the country suddenly comes within the scope of Section 404. And not just land use development. A ditch in your backyard might count as a water of the United States. And if it does, are you liable for violating the Clean Water Act if, for instance, you decide to fill in that ditch and dig a different one elsewhere in your backyard? So Section 404 does provide for a permit program run by the Army Corps of Engineers, authorizing the deposit of dredged and fill material. The standard permit's what the Corps calls an individual permit, but which we would call a specific permit, requires a careful analysis of alternatives by the agency to the proposed deposit of dredge or fill material. Feasibility of alternatives, environmental review pursuant to the National Environmental Policy Act, public notice and comment. Indeed, many of these individual permits take many months to process and issue, and the cost of filing and completing a permit may run into the tens of thousands of dollars. And that's not what you would expect a homeowner redoing their backyard drainage ditch to have to comply with. And they don't, because complementing the individual permit system is what the Corps calls general permits, aligning with our terminology. General permits vary in their details, but to take one extreme example, there is a general permit for all fill and deposit activities for reshaping existing drainage ditches. And if you are reshaping less than 500 linear feet of a drainage ditch, and that covers most homeowners, you don't even have to tell the agency you're doing it. In other words, your activity is pre-approved by the agency pursuant to a general permit. No paperwork. In fact, most homeowners who are doing this work probably are not even aware that they're within the scope of the permit or covered by the law. There are other kinds of general permits that the Corps issues that require pre-construction notice to the agency about the activity. If certain conditions are met for certain activities, the agency may then notify the applicant that the general permit cannot be issued and a full individual permit is required. Alternatively, the agency does nothing, and the applicant, after a short waiting period, can proceed under the general permit. In some general permit categories, the Corps has imposed additional specific conditions or terms to meet for particular activities. And the more this happens, these general permits start to look more like specific permits. So having given you a sense of what general and specific permits are, let me back out a little bit and give some theoretical structure to the analysis, a structure that will be helpful later on as I put this in context for our discussions about executive discretion. So first, let's define permits. The definitions under the APA are rather unhelpful. There is a reference to permits within the category of what is a license, and then there is additionally ways that you could then backtrack that to either orders or rules. So we took a more functional approach. We defined permits as powers delegated by statutes to administrative agencies to affirmatively allow an act otherwise prohibited by statute through a discretionary act by the agency that is judicially reviewable. So you might contrast permits with a flat prohibition on a particular action or with a complete exemption from a regulation for a particular action. And note that exemptions or prohibitions might be imposed by statutes or regulations. So I've already noted you can identify two flavors of permits, general or specific. Under general permits, the default is more or less that you can act until the government tells you you can't, by stating that you're not covered by the general permit. Under specific permits, the default is more or less you cannot act until you are affirmatively given permission. And so again, you can see that on the extremes, general permits start looking a lot like exemptions. Specific permits start looking a lot like prohibitions. Imagine the permit that requires tens of thousands of pages of information and might take 20 years to complete and get approved by the agency. That starts looking a lot like, in effect, a prohibition. General permits are generally designed in advance by the agency, and they require less burden on permit applicants. Specific permits are more tailored to the particular circumstances of a particular applicant and accordingly impose more of a burden on the applicant. And I'm going to I'm not going to go through this slide, it's too much, especially with the time we have, but if anyone's interested in Q&A after the fact, I can sort of go through many more, so the complexities of how the different characteristics going from general to specific permits. But the point I want to communicate, and this prior slide does it even better, is there's a continuum between the two flavors of permits. You might see a permit system with some of the components of a general permit and some of the components of a specific permit, or of an intermediate nature in between. So why might you use a general permit versus specific permit? So some of the reasons that are relevant to our discussions here today are permits can be a significant barrier to entry for new participants in an industry or a field. If you're concerned about permits being barriers to entry into an industry, you might prefer general permits because they are much lower barriers to entry. Second, because the default under a general permit is that the regulated activity can proceed, it's a lot harder for an agency to use delays in authorizations or arbitrariness in permit approvals to discriminate against different applicants. In other words, agency discretion under a general permit system is significantly lower. And finally, general permits have much lower administrative burdens, often none, on regulated parties. To the extent that administrative burdens lead regulated parties to avoid applying for permits, this is a good thing. So to summarize what I mentioned before, compared to prosecutorial discretion, general permits have a range of benefits. They're more predictable. They'll be laid out in public documents with relatively clear standards. And of course, prosecutors can give guidance documents that attempt to provide that kind of predictability, but they often have less legal standing or effect than a general permit and the regulations it's based on. General permits may encourage more reliance by regulated parties, since as with all permits, there's a legal process that must be followed before they can be revoked. And they may constrain agency discretion more than prosecutorial discretion because there's a possibility for judicial review of the denial of a general permit, again, unlike the exercise of prosecutorial discretion. So does this mean we want to use general permits all the time? No, they do have their disadvantages. So there may be times we want to tie people up in red tape for specific permits. We may like deterring entry into a new activity because it is socially harmful, and we only want people doing the activity if we think there's a lot of benefit from the activity to offset the social harm that they'll otherwise cause. If there's a lot of benefit to what they're doing, then it's worth it for the applicant to put the time and effort into the specific permit application, and we're better off as a society. This is what's been called the costly screen mechanism behind regulatory systems. If the activity you're regulating involves potentially high levels of harm that might potentially vary in level and kind from case to case, or even in terms of how the activity is conditioned or undertaken, then you want careful tailoring of a specific permit to reduce the risk of harm. On the other hand, if the activity in question presents low harms, individually and cumulatively, or if the level of harm doesn't vary very much across the activities you're regulating, you might prefer general permits. Specific permits probably make enforcement easier. The agency has a lot more information about what people are doing and where they are doing it. And if you think more enforcement is a good thing, then you like that. And specific permits generally make public participation in the permitting process easier. So this may allow third parties, whether it's environmental groups or other industry entities, to constrain agency discretion more than in the context of general permits. Finally, I want to talk about why we might even prefer prosecutorial discretion over general or specific permits. My thinking here is tentative, but there's some ideas. So we might like the uncertainty that prosecutorial discretion produces in regulated parties because it deters activity that we don't want to occur. So even though we may not be able to in practice control all the activity, the threat of random, arbitrary prosecution will reduce it to some extent. The activity we are regulating is one that we might want to stamp with strong overtones of social moral condemnation. We don't care that people doing the activity may be subject to arbitrary discriminatory prosecutions because they shouldn't have been doing what they were doing in the first place anyway. And finally, we may not think the costs of widespread discretion in terms of political or pecuniary corruption are high, either because there isn't much money in the regulated activity, so no one's going to pay much in bribes in the first place, and or we think there are sufficiently strong political norms against the use of prosecutorial discretion for political purposes. So think of, at least in theory, the strong norms in the US against using tax enforcement for political ends. Even if that occurs on occasion, no one wants it to become public because the backlash on it would be severe. So I think I'll stop there. I have additional thoughts I can share in Q&A.
Well, I think you've scared us enough now in terms of that. Now I'm going to turn it over to Mark, and he's going to be talking about what Barron and Rakoff call big waivers and connect the phenomenon to two things. I think difficulties in legislating in an area of gridlock and more so the relationship between big waivers and the idea of democratic experimentalism.
Hey, thank you. And again, as with everyone, I want to thank Michael and the Center for requirements under certain conditions. And I'll specify those conditions in a moment. As I understand it, there are now 43 states that have waivers from no child left behind. So instead, it's sort of interesting question to ask, well, in what sense is no child left behind a single statute applicable nationwide? The second example are a couple of provisions in the Affordable Care Act, not the waiver that Jonathan may be talking about, but there's a provision allowing a waiver with respect to the establishment of state exchanges, which Vermont, I believe, has invoked in order to have, instead of a state exchange, a single payer system in Vermont, and a waiver provision dealing with Medicaid expansion, which a number of red states have invoked to obtain waivers of the requirement that you expand Medicaid, and they get the waiver by showing, again, in the way I'll describe in more detail, that roughly speaking, the population that would have been covered by an expanded Medicaid program will be covered by this alternative that the state is proposing. So the outcome will be equivalent to that achieved by the Medicaid expansion. Now, I want to say just briefly a few things about the legal issues associated with these waivers, and then turn to the policy questions. So the legal issues are whether the waivers, at least as implemented, are statutorily authorized. Now, that's a statute-specific question, but it's important to understand that these waivers are done under at least the nominal authorization of a waiver provision in the underlying statute. So the No Child Left Behind Act says, in effect, if you can show that you're going to do something to achieve educational outcomes roughly equivalent to those that would be achieved under the provisions of under the substantive provisions of No Child Left Behind, then you can get a waiver to do the things you propose to do. There's a provision in the statute that says that, and similarly with respect to the two kinds of waivers that under the Affordable Care Act that I described. Again, the waiver that Jonathan may talk about comes under a different provision. But the existence of the statutory authorization means that at least at the first cut, these waivers are not the exercise of the power to suspend the underlying law. They are, again, at a first cut, authorized by the underlying law. Then the second legal issue is whether these are constitutional. under the non-delegation doctrine. And here the language of them matters. So I just a third example of a big waiver statute that Barry and Ray reviewed briefly because it's less theoretically interesting is the Border Fence Statute. The Border Fence Statute says that the Secretary of Homeland Security is authorized to waive all legal requirements the Secretary determines necessary to ensure expeditious construction of the border fence. And pursuant to that authorization, Secretary Chertoff suspended, waived over 35. I stopped counting. It's somewhere between 35 and 40. My eyes got blurry. Over 35, mostly environmental statutes associated with the border fence. That was challenged. The waiver provision was challenged as a violation of the non-delegation doctrine. The lower court upheld it, and the Supreme Court summarily affirmed, I believe, but it may have denied review. But in any event, it was upheld. So under the intelligible principle doctrine. So the intelligible principle doctrine is, roughly speaking, as I teach it to my students, the intelligible principle doctrine is, if this is clearer than the thing that they upheld in Whitman, it's an intelligible principle. That's actually the structure of Whitman's analysis. The thing we're upholding here is at least as clear as the things we've upheld in the past. And so that's intelligible. So in both the No Child Left Behind and the ACA, the statutory provision authorizing the waivers say, again, I'm being rough here, that if you show that you can achieve results substantially equivalent to those that would be achieved under the substantive statute, then the Secretary is authorized to waive the substantive provisions. Okay, so now finally I want to turn to the policy issues associated with these. As Judge Callahan indicated, I think that these big waivers are an interesting example of experimentalist legislation of the sort that Bill Simon referred to yesterday. First of all, they are a move away from command and control regulation. What I've been calling the substantive provisions of No Child Left Behind are command and control regulations. These are not that. But they're not fully devolutionary or a new federalism. They don't say the states, if you don't want to, you don't have to comply with No Child Left Behind at all. Rather, there is a central identification of goals, the goals of No Child Left Behind or the expansion of medical care. And there is a presumptive or default method of achieving those goals. But the waivers allow for the displacement of default through an interactive process between the state seeking the waiver and the secretary of the relevant cabinet department, meaning the staff of the agency. So you can displace the default, again, if you can make this kind of showing. Now, again, this is not deregulation. I mean, it occurs in the context of regulatory requirements, but it's not, as I say, command and control requirements imposed on the states. What are the advantages of this kind of mechanism? Well, the No Child Left Behind probably illustrates the primary advantage. It turned out that the substantive requirements of No Child Left Behind were not terribly well designed as a matter of educational policy. They may have been thought to be good at the outset, but it turns out that they're not really all that good. And the waiver process allows for learning from experience. Now that we know that No Child Left Behind's substantive provisions don't work very well, let's see if there are other ways of achieving the goals that we still think are worth achieving. And then, so the states come in and they apply for these waivers, offering, importantly, maybe 43 different alternatives to the substantive provisions of No Child Left Behind. And then these waivers conceptually should be time limited. And so you see what happens under the 43 different ones, and it turns out that 20 of them don't do any better than the substantive mandates of No Child Left Behind, but 20 of them do actually quite well, and actually maybe even better than you thought that the No Child Left Behind requirements would do. And so when people come in for a renewal, you can say, okay, we're not going to let you do those first 20 that didn't turn out to be good, but if you want to tinker with the other 20 and see if they will, you can improve on them, that's fine. The center can modify the presumptive means, and at least conceptually and in some context, it might be able to reshape the goals that are laid out in the statute. At the very least, the learning that you gain from the waivers allows you to formulate proposals for new legislation that incorporates the learning. And it might be that the underlying statute would authorize some degree of modification of the goals themselves. That again would depend on the existing statute. So you can one interesting characteristic of this process is that there can be a modification on the basis of learned experience, and the second is that the process is, at least in some, I think, significant sense, interactive and quasi-participatory. I say quasi because it occurs at the level of the secretary and the secretary's staff and the State Department agency head and staff as well. Okay, two final points about this. First, one question is just whether or to what extent the waiver process, the big waiver process, is reconcilable with the existing Administrative Procedure Act. And what we'll hear at the wrap-up may shed some light about what might be done if it isn't. Second and finally, No Child Left Behind was a product of a different political environment, bipartisan support for it. The Affordable Care Act has its own peculiar location in politics. And to just raise the question I raised yesterday, are further experimentalist or big waiver statutes politically achievable in a gridlocked world? Here, Professor Postel's observation about my comment seems to me relevant as well. I said, again, drawing on Sable and Simon, that the conditions in a gridlocked world for experimentalist kinds of statutes would be agreement that there is a problem and agreement that something, and here I have to say something public and governmental needs to be done, but there's wide disagreement about what should be done. Under those circumstances, you might be able to generate a statute that has some presumptive means with a fairly substantial big waiver provision in it. Thank you.
Thank you. As the moderator, I'm supposed to, sort of sum things up at any point. So after 3 speakers, where's the rule of law? I don't know. But maybe Jonathan's going to answer that, and we're still looking. And
that's what they
you might have to follow the law, but then you might not have to follow the law. So, Jonathan?
Thank you very much, Judge. First of all, once again, to join my colleagues, I want to thank you, Judge, for agreeing to be our moderator. I want to thank Michael and Stanford for putting together this extraordinary conference, and it's an honor to appear with my colleagues here. I thought all of the comments that preceded me were incredibly interesting and far more interesting than what I'm about to say. I wanted to talk a little bit. The interesting thing is, what interests me has parts of all of the preceding comments with possibly a slightly different take. I mean, we all agree that we're in a period of tremendous conflict between the branches. It makes it very interesting for academics. If you come to watch the cars crash, it cannot be a more interesting period. From immigration to global warming to healthcare, We have these conflicts occurring across the board. In my view, we have what is a demonstrably dysfunctional system, and I think is a dangerous situation that is not being addressed. I think that part of the problem is how these conflicts are being presented. I don't agree that this is just an issue of gridlock. Gridlock is often a term that people use when Congress doesn't do what they want to do. Global warming is a very good example. As Don Elliott said earlier today, although there was a question that raised the counter view, many people don't agree on global warming. I happen to agree with the administration, but many do not. In fact, one could say a clear majority are certainly not in favor of taking serious action. Is that a problem with gridlock? Maybe people in Congress simply don't want either to accept that this is a problem, or they don't believe it, and also they don't agree with the solution. That would seem to me to be a process of a representative government, but we can portray that as gridlock as an excuse to circumvent it. But that creates a very dangerous precedent. The fact is, the thing that I found most interesting about the comments from many of the panelists is that we all seem to agree that our system is changing. We've all been writing about that for some time. And yet it's not changing with any real public debate, certainly no public decision. It's basically an elite discussion of people like ourselves. The public is not really involved and probably won't be involved as a fundamental change occurs in our government. Now, some of the specific issues that we've talked about, we've already touched on. But my greatest concern is that we have across the board these conflicts without any limiting principle. When we focus on them in their insular components, we can agree or disagree on the outcome. Issues like the take care clause that Zach was talking about, the cancellation power when you see with immigration. The question, of course, is what is the limit of executive power in such an agency decision? The president's position has been that he can't exempt millions of people. I happen to, once again, agree with him. I'm in an enviable position of representing his political opponents in one sense and not another. I am honored to represent the House of Representatives. I agree entirely with our case. But I happen to agree with all the president's policies. I happen to agree that almost across the board that he has taking the right course. But that doesn't really matter, does it? It doesn't matter whether he's right or wrong. The question is, does he have this authority? And what bothers me about the immigration issue, and you see this in the letter that was signed by immigration lawyers, is I could not find in that letter any limiting principle. What came out of that letter for me was that as long as the president is deporting one person, the rest of it is prosecutorial discretion. And that cannot possibly be the rule. And it's certainly no prosecutorial discretion I've ever seen. I'm a practicing criminal defense attorney, and if I went up to a prosecutor and said, look, I'd just like you to drop the charges against my client and everyone like him, I would be laughed out of the office. Now, the same is true with other aspects of these conflicts, ranging from the no defense of DOMA and when the administration will not defend federal laws. These are difficult decisions, the answers of which we don't seem to be supplying. The one thing I particularly liked about, not the one thing, but one of the things I liked about Zach Price's discussion is his discussion of constitutional architecture and what it means. I might have time to talk about it, but my academic research in the last couple of years has been on what I call a con-architectural approach to separation of powers, and it's a look at constitutional theory and architectural theory to re-examine the meaning of structure, what structure means. Is it truly just a matter of sort of consequentialist concerns about how structure works in a constitutional system? Or is there a separate sort of normative value to structure? We often talk about formalism and functionalism, but we don't really talk about structure itself. In my view, this interdisciplinary work between architectural and constitutional theory is actually much more productive than people would have assumed, because we often treat our two disciplines as so fundamentally different. And maybe I will be able to comment on that in the end, but we don't have a great deal of time. So let's turn to the current crisis and how that plays out in light of some of what my colleagues said, and also how I think it should play out. As I mentioned, I don't consider this a gridlock issue. I certainly don't agree with the idea that we're just living in poisonous political times. That's another way to avoid the constitutional question. As virtually everyone in this room is aware, these times are, if anything, tame in comparison to what happened in the early republic, when Thomas Jefferson referred to his predecessors in the Federalist government as the reign of the witches. While we say that it looks like the Democrats and Republicans want to kill each other today, we have to keep in mind they actually were trying to kill each other with the Alien and Sedition Acts. So we can put that aside. I also don't subscribe to perhaps a more common theme in some of the statements in this conference, which is that our current dysfunctional government, and I don't know anyone who looks at our current situation and says, there's a good model of governance. Okay? None of us are taking that position, I hope, that you look at the status quo and say, this works pretty damn well. I like what I see. But I don't believe that the two parties are responsible for this dysfunctional system. I happen to blame the courts, and I have for some time. Particularly, not just as an academic, but someone who works with Congress, to me, all of the things that we find dysfunctional about the current system is due to the erosion of clarity and the separation of powers. The courts have largely removed themselves from defining and maintaining basic lines of the separation of power. And what they do when they do that, when they remove themselves from that issue, is they leave the two parties to muscle politics. That's what you get. There's no resolution. So both parties and both branches go at each other in a increasingly dysfunctional way. And I do not blame the political system for that. I blame the courts. I believe the courts have created this situation through things like the standing doctrine to make it into this grotesque barrier to even the most fundamental separation of powers conflicts. And in that sense, I obviously disagree with cases like Raines and some other cases. But when you read those cases, the position, as the court said, it says we must put aside the natural urge to proceed directly to the merits of this important dispute and to settle it for the sake of convenience and efficiency. The court treats these separation problems as people coming for convenience to the court. And what has followed Raines is an absolute morass. There's no convenience there. We're having a serious shutdown in government. I don't know anybody in Washington that likes the situation. But the position of all this judicial avoidance has been basically that, essentially, if, according to Smokey the Bear, if only you can prevent wildfires, then only you can put them out. We'll just let the houses burn because that's better for fire protection. You can put out the fires or not. That problem is getting worse. I mean, in my view, we talked about Arlington versus FCC. I consider the decision to be wrong. I happen to agree with Chief Justice Roberts about giving deference on a question of defining jurisdiction of an agency. I think that is the further continuation of the problems we're having in terms of deference. So before I get to the current cases, I want to note that when you argue these cases and when we talk about them in Congress and in academia, we often hear this mantra that putting aside where we draw this line, putting aside the standing questions, don't forget you have the ability to protect yourself. You have the power of the purse, you have oversight jurisdiction, and you have impeachment. Now, as someone who testified at the Clinton impeachment and handled the lead on the last judicial impeachment, I find it absolutely astonishing that anyone would suggest that impeachment is a meaningful tool to maintain the separation of powers. It's like running a nuclear plant with an on-off switch. I can't imagine why judges say that, but they do. They said it when I argued the Libyan case. The judge looked at me without breaking a smile and said, well, you always have impeachment, as if that's a meaningful limitation, but more importantly, something that the framers really anticipated would be the active component in maintaining the separation of powers. The cases that I wanted to focus on, and the one that Mark alluded to, are two cases that have been described as existential threats to the ACA. One is King versus Burwell, which is in front of the Supreme Court, of course. We're waiting for a decision in that case. The other one is the case that I'm leading on, which is House of Representatives versus Burwell. The cases themselves are actually are substantially misinterpreted in the media. They turn on two different sections, Section 1401 and Section 1402, but they certainly share analogous questions under the separation of powers. King turns on the language in 1311 that directs states to create exchanges. And 1321 says that the federal government can establish exchanges within a state when the state fails to do so. The real key is then 1401, which authorizes subsidies or tax credits for states in dealing with this differential between affordable health care and what people can pay. And it specifically has the language that this subsidy can go, quote, through an exchange established by the state. For many of us, we view that language as quite clear. I happen to. But there could be arguments on either side. What the administration did not anticipate, and by the way, the rather unfortunate Professor Gruber at MIT, when this thing was first put together, he said on two different occasions that the meaning of this language is simple. If you're a state and you don't set up an exchange, that means your citizens don't get tax credits. Okay? When you read the provision, that's how it reads. And when you think about the provision, I understand people saying that this is a uniquely stupid way to go about things, but we don't apply that standard to Congress or everything would be struck down. The issue is, do they have a plausible reason for this language? The answer is, of course they do. It's a traditional carrot-stick approach. You put together a state exchange or you get punished. Good state, bad state. Now, we can disagree with whether they should have done it, but they did it. But what happened was that the administration, I think, was taken by surprise when 34 states did not create state exchanges. I think, frankly, that was the biggest surprise they had post-ACA. And that really did present a massive threat to the ACA. It would collapse. And so the administration decided to interpret this through an IRS interpretation that said that even though it has this provision for state exchanges and federal exchanges, we're just going to treat them all the same, so that even if you didn't create a state exchange, you still get the money. And that guaranteed that people would be kept in the system, that guaranteed that money would go out of the system. As many of you know, that led to the decision in Halbig, where a divided DC panel said this is unconstitutional. And then within hours, just across the river, the Fourth Circuit handed down its decision in King and said it is constitutional. Okay. The second issue involving this type of agency decision is in our case, in the United States versus Burwell. That's 1402. Now, we have the employer mandate, and I'm not actually going to be talking about the employer mandate much, but just to explain the difference between these sections, because there's still a lot of confusion between the two cases, we might as well clear them up. 1402 is as clear a power of the purse case as we've ever seen in the history of this country. It is very simple. 1402 is the provision that takes money from the Treasury and potentially gives it to insurers. So when insurers are guaranteeing those affordable policies and they take a hit, the United States government said that it may reimburse them through 1402. The problem is that because of the way the ACA was written and the disagreements with the insurance companies, Congress never appropriated the money. Now, after ACA came out, the administration came to Congress and said, now appropriate the money, and Congress declined. And the administration came a second year and said, we need you to appropriate the money, and Congress declined. And then in the third year, they came out with a new interpretation saying, forget all of that, we are now going to treat this as a permanent appropriation. And I'm going to wrap up all this wonky stuff. But this is why, as a constitutional law professor, this case I find absolutely intriguing, if I have to say so myself. As all of you know, there are basically two forms of appropriations that underlie the power of the purse. One is the most common, which is discretionary appropriation, which occurs every year. It gives Congress a chance to pull it, increase it, shrink it. It's a classic application. In a smaller, much smaller percentage of cases, you have permanent appropriations, which is basically a credit card to go right out of the Treasury. That's where you get your tax refunds from. Congress looks at those extremely closely before they approve it. What the administration did is it declared that 1402 was now a permanent appropriation. So you had a president who was saying that $178 billion up front would be removed from the Treasury based on his new interpretation of an appropriation that was never made. Now, these are all different types of aspects of agency interpretation, but our case, particularly in terms of the power of the purse, makes a mockery out of what the courts have said, you always have the power of the purse. Our case shows we don't have the power of the purse. If the president can simply convert an appropriation into a permanent appropriation. The primary issue then, and this is, I'll wrap up on this issue, is can this case be heard? Here you have as fundamental an issue of power of the purse as you could possibly imagine. This is it. I mean, it's the most serious attack on the power of the purse in history of this republic, in my view. I'm getting the hook.
It wasn't really going to happen until you blamed everything on the court. But he told me what he was going to talk about. But Jonathan, you actually neglected that part of it. But you're a very good lawyer, and I still would hire you. But I'm going to have my rebuttal time. But.
Okay, well then I'll take that in mind. I'll try to clean my act up in the last 2 minutes. In terms of standing. I've been an advocate of legislative standing for years. In fact, Walter Dellinger and I just testified, and he had a great line because he said, the problem is you're hearing from two people. I'm a standing hawk, meaning Walter. I have trouble with a lot of people getting into court. Turley's a standing dove, and he'd let anyone into court. And the answer probably is somewhere in between. And I think Walter was right. The answer probably is somewhere in between. But in my view, that answer would have to include legislative or member standing. A lot of these issues could be resolved if members can appear. Now, the question is how many members? And when I did the Libyan case, I was told, look, you just represent some of the members of the House, not the House itself. Well, I'm back, and I now represent the House, and we're going to have to see if that goalpost moves again. But to me, the standing doctrine has lost all semblance of reality and functionality. It has become grotesque. And I'd be happy to talk about that with the questions. Thank you so much, Judge.
Thank you, Jonathan. I think I think we've now heard a broad array of opinions on this, and I'm going to be posing some questions. I suppose in my rebuttal, however, like I said, I think you make your case very persuasively, but I would have to say at the end that I don't really know that the courts are responsible for everything that is wrong. In the separation of powers, and when you talk, I think I agree with Jonathan on this sense that you can't blame everything on gridlock. I think it really is the separation of powers. So I'm going to blame everything on the Constitution. And so when you get a result that you don't care for, that perhaps on standing, that it may have something to do with what the Constitution sets out in terms of what the federal courts can hear. But I do think that all of the issues that we're talking about, and we're going to explore this, we've mentioned, I think, the Affordable Care, immigration, all of those, when there are problems and when there are issues, how people define separation of powers, and when there are problems, I think people tend to overreach, and it blurs the lines, and I do think separation of powers continues. It is very important. And when I sit on the Ninth Circuit, and everyone, if you follow the Ninth Circuit, we don't look at things all the same. And there are some people on the Ninth Circuit, it could be argued, look at the law as a mere suggestion. and as opposed to what would be controlling precedent. But I say that jokingly, but I think in the immigration area, I have one colleague, for example, that says, I do not think anyone that has a citizen-born child should be deported. Unfortunately, that is not the law. But really, when we're saying what is the rule of law, now we have the executive order that is going to qualify certain people to be spared deportation. And I will tell you, 40% of the caseload on the Ninth Circuit, even though we order how we hear them, is immigration. And we decide these cases, and people have deportation orders, and nothing ever happens. There are people that have been here forever. So it is a complicated problem, and when there are executive orders, if people think you can in your heart say, I really like that result, but then who they decide gets to stay and who doesn't get to stay, and all of those things, ultimately, when you're sitting in a court, fairness in following the law, and I think Jonathan knows this, is sometimes a bit more complicated than that. But as a first question, as we were talking about immigration that we might flesh out are the different perspectives we've heard. Is the legality of the executive order on immigration? Executive enforcement discretion is presumptively not subject to judicial review, but the executive order on immigration is a broad governmental policy, not an agency decision, to not enforce the law in a particular way. Is this a codification of agency enforcement discretion akin to a general permit, and thus like a permit, subject to procedural requirements under the APA and judicial review? In other words, are judges authorized to decide whether, in limiting its ability to enforce immigration law, the executive has impermissibly snubbed Congress and overstepped its bounds? If so, what are the standards for judicial review, and what would be the remedy? Jonathan?
Oh, you want to start with me?
Well, I think I owe you that.
Oh, okay. I don't blame you for everything. I'm a Cubs fan. I believe fate has a lot to do with things. And I've given up hope in certain areas like that. I thought you were going to turn to Zach on this, because I thought that Zach's discussing the sort of cancellation authority was particularly interesting.
Well, he can start if you'd like.
Sure. I'll be a little bit equivocal about it because I think the immigration case is somewhat complicated. In principle, I think, not everyone agrees with this, but I think that the immigration programs go beyond normal enforcement discretion. And that's because they have a prospective dimension. It's not just, we can't enforce the law against everyone, so we're going to enforce it against, remove some people and not others. That's totally conventional enforcement discretion. But these programs invite very large categories of people, subject to removal under the statutes, to apply for an effective sort of permit to stay in the country for a specified period. So, I should say, I'm very sympathetic to the policy. So arguing against myself to some degree, but I think that as a general model of enforcement discretion, it's not doesn't work. So to give a kind of another example, imagine if OSHA said, we can't find everyone who has an unsafe workplace, so we're going to invite 40% of employers with unsafe workplaces to come in and tell us that, and we'll give them a 3-year promise that we won't cite them for any violations. Just to give it this prospective sort of assurance of non-enforcement is, I think, what takes it outside of normal enforcement discretion.
Well,
now,
would you see that working through the courts?
Yes. Well, so with the courts, the question is then, what makes it complicated is that OLC, I think, to its credit, recognizes that and has made an argument that it's sort of implicitly statutorily authorized. I think that's going to be the focus of the analysis in the court. In terms of the specific holding of the district court in the case, I think there's an interesting question there in terms of, he of course held that it's because it's a rule, it should be subject to notice and comment. And I think that gets at some of the sort of judicial manageability problems I was talking about, because on one level that makes a certain amount of sense. I agree with the judge that in practice this is likely to be a program that operates in a rule-like fashion, and certainly in terms of its importance and magnitude, it's something where you might think notice and comment is appropriate. But the question I have about it is that the program formally at least has a kind of case-by-case dimension. And I think that in practice, that's really going to be just a sort of safety valve for cases where that are really exceptional. But the thing is, a lot of enforcement policies have that same sort of character, and I'm not sure that courts can very effectively go beyond policing a requirement that enforcement policies be framed in that way, in a sort of non-committal priority setting sort of fashion. If you're going to look under the hood and try and say that it's being implemented in a way that's not actually priority setting, has a more rule-like character, then I think you quickly end up in the sort of problem I was describing. So I think the right way to think about why it's different has more to do with the kind of scale of it and the prospective character of it, and that's a potentially. I'm not sure about that aspect of the analysis.
Well, you worked in the cert pool at the Supreme Court, right?
Yes.
So Supreme Court going to take this?
I mean, I have no crystal ball.
And what would they decide?
And you clerked for Kennedy, so you can answer
Yes,
this question.
I
How
can-
would Kennedy
I
write
can
this
tell
one?
you the answer right now. No, I mean, it's certainly a very significant issue. So in that sense,
Well,
I mean,
but
it
going
needs-
on what Jonathan says,
Yeah.
I mean, this seems like this is it. I mean, the courts are right in the middle of it now, so shouldn't the court say something?
depending on how the litigation unfolds, I think it certainly could be a very good candidate for cert. Yeah.
You know, the interesting thing that one of the things I thought was most interesting about Zach's paper is when you look at things like immigration, there are reviewable elements in there. You know, this issue of prosecutorial discretion has raised a subsidiary question of whether this is truly an exemption of millions of people. The administration wrote it in a way that made it look like there were factors that would still be considered by prosecutors and by people on the ground. And yet Congress has published things suggesting that it is in fact a complete exemption. So the degree to which you're relying on prosecutorial discretion, there's the subsidiary question of whether the court then should determine if this is true prosecutorial discretion or an exemption, whether that's reviewable. And I also wanted to note, both Eric and Zach turned on this issue of discretion and also dates. I believe it was Zach that said, you know, if you're postponing a date that might be, I might have heard you wrong, that might be something a court could in fact review and police. The one thing that I wanted to add is that when you look at things like the employer mandate, it is not just simply the movement of a date. A part of the oversimplification of this issue is that that start date was not just when you would enforce the ACA, it was also the date when certain products in the market, insurance products, would become illegal. So you could no longer on that date issue certain insurance policies that Congress had determined were abusive, that they were not acceptable. So we often oversimplify, says, well, agencies move dates. So many of these dates are actually rollout dates for products, but also termination dates for other products.
I wanted to ask, did you like to comment
Yeah,
on that?
I'm trying to get to Google on my phone. So OSHA actually does have a program, which they publicly announced. So the Voluntary Protection Program. The Google doesn't tell me fast enough to give you the details.
You can go down the street and tell them that.
Yeah.
But it is, yeah, an employer comes in and says, I have an exemplary safety program. It doesn't mean I'm zero compliant, things. And OSHA looks at it and then they do something, but it's not just they get a gold star. I mean, they get some benefit out of OSHA from participating in the voluntary program. So, and it is right here.
Well, I mean, it could be wrong, but I mean, my impression of this type of program is generally like I know OSHA had a program where you know, if you have certain internal compliance measures, then we're going to focus on other employers, and that seems reasonable to me because it advances the overall statutory objective of compliance. I think that there are often sort of amnesty programs where if you kind of come clean and then we won't come after you. But again, that has a sort of the overall objective of the policy is prospective compliance. And so, you know, perhaps I need to frame the hypo in a more extreme way, or perhaps that one doesn't work. But my point is that in general, it's not going to be consistent with it's not enforcement discretion to license someone ahead of time to do something that's prohibited by a statute. Enforcement discretion is turning a blind eye to completed violation. And there are a range of different things that agencies can do that are faithfully advance the overall objective of complying with the statutory policy. But I think the model of executive action reflected in the immigration example is not one that can readily be generalized to other contexts as a model of faithful execution of the law.
I want to turn to framing an agency's permit or waiver as authority to make exceptions to the law that seem to highlight the separation of powers concerns attendant to delegations of broad lawmaking authority to agencies. As I see it, Congress creates a law prohibiting an activity but authorizes an agency to undo or to suspend prohibition without bicameralism or presentment. Judges are then inevitably told to defer to the agency in interpreting the law. Can we agree that this model of governance has the effect of consolidating judicial, legislative, and executive authority in the agencies?
No.
All right.
Well, let me qualify that. I don't think you have a choice. I mean, you could write, so the choice is, do you write a broad law and put no permit or no waiver provisions in it and count on prosecutors or courts or juries to grant the exemptions that are going to occur? Or does Congress write laws at the level of specificity that allow us to determine whether individual actors are or not compliant with the law, which seems impossible? So I don't see how you get out of the problem of deciding whether the law covers particular actors or not. Maybe there's options that are better or worse, but I don't see why the mere existence of permits or waivers is problematic.
I wanted to. Did anyone want to comment on that, Mark?
The Humphrey's executive solution is you call these quasi-executive and quasi-judicial, and then they're not judicial or executive. So you're fine.
Well, I wanted to. Well, I sort of said a little bit about it before I started, and it seems that it's causing the consolidation of power in the agencies, and I mean, isn't that just somewhat legislative gridlock? I mean, it's just keep everything there, and then it never gets out.
I mean, the problem is, I agree with Jonathan, gridlock is a loaded term and it's not the right term to use. Let's just frame it as, if the current Congress doesn't do anything, it empowers old Congresses. And so the issue is not that agencies are necessarily suddenly getting massive new powers. The issue is there's laws on the books, and if Congress doesn't like what's being done with them, Congress could change them. It's not able to do so at this time. And of course, there's the challenge that you have to get presidential approval. You have the presidential veto. Every 4 years that can change. So that's part of it as well. But I think of this more as a problem. It's not gridlock, I agree with Jonathan, but I think this is a situation where, and this is classic McNoll-Gass poli-sci, right? It's old Congresses are afraid or concerned about what new Congresses will do, and they do try to constrain that to some extent, but it's always about, in some ways, a battle of power between the old Congress and the new Congress.
Well, let me build on that I wanted to, an issue that appears to be gaining traction is whether the highly deferential standard of review applicable to an agency's interpretation of its own regulation under Auer v. Robbins ought to be abandoned. I mean, last month in Perez v. Mortgage Bankers, in separate concurrences, Alito, Scalia, and Thomas expressed the view that Auer was wrongly decided. The rest of the court didn't reach the issue. So at least those three justices believe that the agency cannot both promulgate a regulation that creates a law and then be given substantial deference in declaring what the regulation means. So according to these justices, Auer impermissibly allows agencies to usurp both the legislative and the judicial roles. Eric, I know you probably, or Mark, have something. Do you have any view on Auer deference?
I've always hated it, but it's just me.
I don't have any view on that. I suggested yesterday that if if that turns out to be the I don't know what the right word is, the Battle of Gettysburg, of the assault on the modern administrative state, the North has won, because you could take away our deference and nothing significant would change.
Well, I wanna leave some time for questions to the audience, but I did want to address standing that we had talked about previously. And judges frequently have to decide whether an agency has violated a congressional intent or exceeded its statutory authority, but they generally do so in cases brought by private actors who must demonstrate Article III standing, including concrete harm. Now, Jonathan, it seems to me would have the courts interpret Article III to allow lawmakers themselves or the institution of Congress to have standing based on abstract harm to congressional power, even absent a showing of concrete and individualized harm. Do you want to comment on that?
Sure. Although I'd say I was an advocate for member standing before I represented members, but the blame that I put to judges.
Well, we're going to throw the federal court doors open, and are we going to just have so much to do everyone can come?
Well, first of all, I want to note that I actually don't blame the courts for everything. This is where I say some of my best friends are judges. But I do blame them for standing, which I think is a major contributor to this. And I believe that standing has become completely untethered to its original purposes. And I think when you look at these cases, they're a mess in terms of member standing. The Supreme Court, if anything, has recognized member standing. It's just that they continually sort of cut back on whatever clarity they have. But they're going to have to establish something post-Coleman. In Coleman, they recognized that you had 21 Kansas legislators who were opposing a unilateral decision by the lieutenant governor in that state. What's interesting is they weren't representing the body itself. There was just 21, but that's a majority of that House. And the court did allow that. Also, we saw with Blagg, it was allowed to argue Windsor, although that can be treated as an exceptional case because of the way the case went up to the court. In my view, if you look back at the purposes of standing, look at some of the prudential issues, to put aside the constitutional question, one of the things that we want to make sure of is that you restrict these cases to the parties who will present the best, the strongest, the most committed types of arguments. Members actually fulfill that. I don't think you're going to have this floodgate of litigation with members. I think that's a misconception, but there's not many of them. And judges, I think, can handle that. But what you would get is the ability for judges to deal with fundamental separation of powers questions. And what I think that is otherworldly for framers is when you look at issues like our Libyan war case, where there was a serious question of, do you need a declaration of war here? Is this war? And you had a president in that case. My opposing counsel's position against us in court was that something cannot be a war unless the president calls it a war. That was their position. So as long as the president calls it a limited kinetic action, which I never really understood, it's not a war because that doesn't use the noun. That rather ridiculous position was allowed to be sustained because we could not get standing. And I just don't, I believe that would be an untenable position for the framers.
Well, environmental standing has been fairly liberal.
Really? I actually like the fact you raised that because it highlights to me the 180, not you, I know you've been consistent on this, and I've always been a critic of standing, but the 180 switch on this, right? So what are the standing cases from the 80s? They're conservative justices protecting executive discretion not to enforce environmental laws from citizen suits by environmental groups. So, all of a sudden we've switched around. We've got a lot of rhetoric about runaway executive discretion and the world is collapsing. And, I don't disagree that there's a lot of dysfunction and there's a lot of challenges, but I find it odd how the positions have switched so much without, and this is how it often works, but without a lot of sort of reflection on where people were 30 years ago. and you can distinguish. I'm not saying that you have to have the same positions then that you had now. You could distinguish citizen suits by citizens from legislative standing, and that's, you can make those arguments, but I think if people reflected on the fact, well, that might make the claims about how outrageous what is happening a little less tenable. So on that, my position, I like Jonathan, I've been skeptical of strict standing, and I think it's generally used by courts to get rid of cases they don't want to hear, whether it's because they disagree with it on the merits, but they don't want to get there, or because they want to kick a political hot potato out. And that's why the separation of powers cases. I know what you want to get there, but good luck, because they don't want to do that. It's just going to get them in a mess.
Well, I'm shocked that Eric would say that our Supreme Court is not consistent or principled, and I won't sit for that.
Well, the standing issue did come up in the Burwell, in the King v. Burwell case. It was discussed at oral argument and came up for the first time. And I do want to take some questions, and then I'll close after that with, I gave my panel an exercise. I gave them homework, and I told them they all had to watch the oral argument in King v. Burwell. Some had to, and that meant I had to too. So they have to predict how the court's going to rule on that. So I want a number, and I want which way they're going to go after. But any questions first?
So, Zach, if Mark had had more opportunity to look at the OSHA website, he would have found elsewhere on the website a promise that you're going to be inspected if you have more than 6 times the national average workplace injuries. You might be inspected if you have more than 4 times the national average workplace injuries, but you won't be inspected if you have less than that, just because Congress hasn't given us the funds. We heard several times that the immigration authorities have sufficient funds from Congress for only 400,000 deportations a year. How different is it from the case you were imagining for INS to say, okay, we're going to spend our 400,000 possible deportations on the 400,000 worst folks, define them however you want, but they aren't going to include the DACA and the DAPA folks, and the DACA and the DAPA folks would then know they're home.
Yeah, so I mean, I don't want to get too hung up on OSHA, but I mean, I think conventionally agencies, they have these sorts of enforcement policies. I mean, maybe ideally they shouldn't be so upfront and public about it, but to avoid notice and comment, they generally at least frame them in a non-committal way. So these are our priorities, this is what we're likely to do, but we're not promising that. And so what I'm suggesting is different about the immigration example, although again, I mean, there's a lot of complexity to it, is that it's the government pushing beyond that. And so the analogy would be, I mean, they have a set of priorities that they're not, under the priorities, they would not be removing any of the people who are beneficiaries of DACA and DAPA. What makes those programs different, the reason they have them in addition to those priorities, is that they confer an additional benefit. And my suggestion is just that goes beyond normal enforcement discretion, and that's why the argument there needs to be some more specific statutory authority. And to its credit, the government has at least framed the question that way.
Go ahead.
So I think there's a tendency in some moments to over-focus on 2 particular mechanisms of accountability, non-delegation and notice and comment rulemaking. And aside from the fact that these mechanisms may be inappropriate or burdensome in some contexts, they're incredibly weak and limited in another. I mean, they're just 2 items on a very long list of potential accountability mechanisms. And I think No Child Left Behind is a good example of that. So No Child Left Behind without the waiver provision would be a highly directive statute. And the consequence of the enforcement of those directives would be a result that almost no one in the country and no one in the Congress really wants, which is most of the school systems in the country, including those that are especially those that are racially integrated, would be labeled failing. And they would be subject to potential draconian penalties as to which the federal government would have enormous enforcement discretion of the kind that Zach talks about. That's without the waiver, right? If we knocked out waiver on the basis of delegation, then the waiver process that the government has set up is not only has the kind of self-disciplining criteria that Kenneth Cole Davis argued was the most important form of accountability, but it also mandates at the state level, as a condition of the waiver, a planning process that has to involve citizen and stakeholder engagement and has to have certain types of participation. So the waiver process is a massive increase in accountability and democratic accountability for the administration of this regime. It just doesn't use the two methods that we seem to be overly preoccupied with.
Here and then Cy, and then we'll sum up.
Yeah, maybe this aims in exactly the opposite direction. This picks up on something Mark noted, which is a lot of these waiver programs or discretionary programs, call it what you will, they're federalism programs, right? They involve states, and they operate sort of on a state-by-state basis. No Child Left Behind, the environmental programs, and so forth. So what you're looking at there is something that political scientists call executive federalism. And there are countries around the world that have that, right? And what happens in all of them is that the waivers or permissions, as well as the fiscal transfers and the conditions that attach to each negotiated program, eventually serve the president's power base. Nigeria is a perfectly fine example of how that system works. Argentina is another, Brazil is another. What stands between us and that fate?
Is that for Mark?
A per capita gross national product of whatever, $8,000 or whatever it's supposed to be, right? I mean, right. So what I'm alluding to are these studies that say stable democracies are sustained where you have some number of some figure of the per capita national income, which is high enough, and below that you have trouble. So if we're above there, that's what's going to save us from the fate.
Fine.
These are questions for Zach and Jonathan, but anyone, welcome answers from anybody. For Zach, suppose we have a statute that says you can't drive faster than 55. But we know lots of people drive faster than 55. In fact, 90% of the people drive, up to 65. But there's not enough money to catch them all, and so the executive says, "Look, I want to, target the 65 and above drivers." It seems to me that your principle is that that's impermissible for some reason. They can't do that because they're letting go of 90% of the people, and it just seems counterintuitive to me as to why they would have to take people at each mileage and actually prosecute them. I think all of us sort of know this when we drive, that if we drive 5 miles above, we're probably not going to be stopped, unless we think there's some racial discrimination in enforcement, in which case we might very well be stopped. So I don't share the intuition that if they create a rule which says don't stop anyone above who's going below 65, that's somehow impermissible. And then for Jonathan, I wonder, the absence of suits by members of Congress for the first 200 years, what does that suggest? Because I would assume that members of Congress thought the executive had been not following the law that it passed for many, many different situations, right? We've got the removal of Secretary of War during the Civil War, and I don't know if any member of Congress sues because the president's not following the statute that they passed. And so doesn't that suggest something about standing if we assume there is a constitutional standing requirement?
Sure. So I'd say a couple of things about the speed limit example, which is helpful. I mean, say, first of all, if you had adequate resources to catch people going 55, then it's not permissible to, in general, to make the rule 65 instead. Obviously, that's not the case with driving, with many laws, and that's how we end up with priority setting. Interesting question is, in principle, more random enforcement would be more consistent with treating the 55 as the law rather than the 65. But there seems to be a general understanding that it's also consistent with faithful execution to prioritize the more serious offenses, which is effectively what the 65 rule guidance is doing. But my point is, what you nonetheless can't do is you can't paste a sign over the 55-mile speed limit that says the speed limit is 65. That's the real boundary that matters, is when you go beyond just setting priorities as a reasonable way of effectuating the law and changing the content of the law itself. And that's admittedly an imprecise line, a matter of judgment in a lot of cases, and this is where the immigration example gets complicated, but I think that's the basic principle I'm trying to defend. And the last thing I'd say is that this type of example shows how we're really used to enforcement discretion as a sort of important safety valve for violations that seem trivial compared to the potential punishment. But the sort of broader, if you step back from that, it's not a particularly attractive way for the law to operate in the first place. If you think about the traffic example, is great in the sense that you have an extensive traffic code. Prosecutorial discretion is what spares us all having to comply with it all the time. But then at the end of the day, it leaves you with no kind of an ineffective democratic constraint on the substance of the rules that you can be punished for if the prosecutor decides to go after you. And so I think the overall part of what drives my argument is I think the overall model that we're so used to is actually not particularly attractive if you dig into it.
Unfortunately, I'm getting the hook here because we're going to be going into our keynote speaker. So the reason they didn't bring the lawsuits is because they hadn't met as good a lawyer as Jonathan. And so that's the answer. So I want to thank my panel. They've been wonderful. And all that I want to hear from you, how good you really are, all I want to hear is how King v. Burwell is going to come out. Give me a number and who's going to win, and I'll start. King's going to win 5-4.
I have no insight. I'm just going by the betting line I saw, which is 6-3 for Burwell.
I'll say 5-4 for the government.
It depends if Kennedy gives up his most ridiculous coercion obsession, but I would have to say they would go probably 5-4 for the challengers against Burwell.
4-4-1, and the one is whatever Kennedy wants.
All right. Thank you.